What happens to property and assets located overseas when a couple gets divorced in Singapore? Do the Singapore courts have power over assets in another country? And what are the legal and practical challenges involved? The law does not distinguish between local and overseas assets. If an overseas property qualifies as a matrimonial asset, it will be included in the division. Even though the Singapore courts can make an order that includes overseas property, enforcing that order in a foreign country is another matter entirely. Many courts around the world hesitate to enforce foreign divorce judgments, especially when it involves immovable property like houses and land. What this means is that even if a Singapore court awards one of the spouses half of a property in London or Sydney, it may be practically impossible to make it happen without cooperation from the authorities in London or Sydney. So how do the Singapore courts deal with this problem? There are two main approaches. The first is ordering the sale of the overseas assets. The court may order that the foreign property be sold and the proceeds be divided. However, this depends on whether the party in control of the overseas asset complies. The second approach is adjusting local assets instead. Since enforcing overseas orders is difficult, the Singapore courts often prefer to include the foreign property's value into the overall matrimonial pool but award compensation through local assets. For example, instead of transferring part of a London apartment, the court may adjust the distribution of a Singapore condo or bank account to balance things out.